If everyone could please stand, Chairman Gentry from the Klamath Tribes is going to give a brief invocation.
Thank you. Honored to be here representing our Klamath, Modoc, and Yehuskan Paiute people in South Central Oregon. Let's go before our Creator here this morning and invite His presence. Blaidalkni, not lam, but isap mo sap ketcha, white stitch. Okas, misam jasnini. No playa satnali, ditchiant to toxin again. Sodiwak, duahutno sodiwak. Mo sap ketcha, gao, tzatwalania, scout zamax. One from above, our Father, I thank you for this good day. You are the one who was and will live forever. I pray your blessing upon us, your children today. Help us. Help us to do what you want us to do, Creator. We give this time over to you. And we thank you for this opportunity to celebrate NARF, the Native American Rights Fund, and all that they've done for Native people, and in essence for this nation, to protect in the interests of our Native people and to do what's right. Creator, we know when we do what's right before you, we're in a place of blessing, and we thank you for that. And so I thank you for this good work and for the friendship, for the relationship that we have with all those with the Native American Rights Fund. And we thank you, Lord, for this university and those that have come out of here supporting Native issues and causes and looking out for the future of our people and of our nation. I just pray your divine blessing on this conference, each and everything that's done here and said here today. I pray it be a good thing and bring honor to you and honor to the people that are here. Creator, I thank you for your presence. I pray and ask this in Creator's Son, Jesus' name, Jet Smart. Amen. It's all been said. Thank you. Thank you. I certainly am honored to be here to celebrate and honor the Native American Rights Fund for their many years of service to Indian country. And I was a young person when folks from NARF came to our country, the country of the Yuskani Muklaks, the people of the lake, the Moatkani, the Modoc, the Numu, the Paiute people, the Yuskan Band, the Snake Indians. All those are the folks that are a part of our Klamath Treaty of 1864. And folks may know some of our history. You know, we have a pretty tragic history, you know, with the loss of our reservation and termination, and I'll be speaking a little bit more about that a little bit later. But I was a young boy, and my father was teaching my brother and I how to hunt, fish, trap, and gather, and take care of our people as we have for the centuries, the thousands of years before my time. And we were being challenged by the state of Oregon whether we had treaty rights or not, because we were terminated and lost our reservation. And I was a young boy, and my father, who was a long-term friend at NARF and was on the board years ago, started teaching me some things about our treaty. And many of it, the things I've learned, I just absorbed from just being around him. But the Native American Rights Fund, I mean, it was just as like early Indian law. I mean, there wasn't such a thing. And we had folks like Don Wharton and others come, Don Miller. We've had a long-standing relationship with folks in our area. And when I think of all that is meant to us as a people and meant to me personally, the success of our Campbell versus Callahan treaty rights case, you know, which affirmed that we still had the right to hunt, fish, trap, and gather, a right that we intended to reserve when we negotiated the treaty in 1864. And You know, that case was, of course, a landmark case, but it's meant so much to me personally. I was a part of Campbell 2. The state of Oregon argued that our treaty rights were basically an individual right and died with our tribal members that were enrolled at the time of termination in 1954. So they argued that once those people died, the right died with them. Well, my father marched me out, and my brother out, in probably the most public place to fish on the Wilkinson River, so we could be cited and be a part of the Campbell 2 case. So I'm sharing these things because, and I know that many others in Indian country probably have similar stories and similar feelings, and want to honor and thank NARF for their many years of service to the Klamath tribes. I see Charles Wilkinson here too, you know, a long-term friend, and many advocates, Ada Deer, Suzan. We just so much appreciate all that you've done for the Klamath tribes. And so I'm honored to be here to share these few words and, you know, to commemorate the 45th anniversary of NARF and celebrate with them the wonderful things that they've done. And we have new friends that we've met over the years, David Gover, Sue, Noe, others, Richard, I think I saw here earlier. But honored to be here to share these words, and this is a wonderful time of celebration, and I expect good things today in the presence of our Creator and one another, and just so mindful that we need one another and that we all have our place and our role in the wholeness of what Creator intended. So I'm honored to be here and be a part of this. Thank you.
So my name is Phil Weiser. I'm the dean here at the University of Colorado Law, and I am humbled to be here. The legacy of NARF and the importance of American Indian law as part of this law school is paramount. The founding of NARF, which started with David Getchis and then Tom Fredericks and now John Echohawk, is intertwined with our law school. A number of our students have worked at NARF. Graduates like Stephen Moore have gone to important positions there. And that relationship has been incredibly powerful for us and has continued to support a vibrant American Indian law program here, both from a curricular standpoint and from an extracurricular standpoint, conferences like the one we're having today. David Getchis, as you all know, passed away 4.5 years ago almost now, and we had a memorial service for him that paid tribute to his leadership, and that continues to be a source of inspiration. His partner, Charles Wilkinson, is with us here today, and in their honor, we have named our Natural Resources, formerly Natural Resources Law Center, now the Getchis-Wilkinson Center for Natural Resources, Energy, and the Environment. We'll be celebrating Charles' impact in those fields, including in American Indian law, in a conference March 10th and 11th. I invite you all to join us back then. We also have Professor Rick Collins, who had worked with NARF and argued many important cases, will be here later today, and a new generation honor faculty who continue to carry this important project forward. Carla Fredericks, who's the director of our American Indian Law program, and Professor Sarah Craigoff and Kristen Carpenter, who I know you know well. So I mostly want to underscore that we're both looking backwards but also building forwards. And for the next 45 years, it's an inspired plan to have this sort of conference. It takes a lot of work to execute it. So I'd like to just acknowledge Carla Fredericks for her leadership and helping to pull all this together. So Carla, thank you so much. You did great. And as you think about the future, what I would say in terms of my contribution, and this is something that I know very much in the spirit of how David Getchis and Charles Wilkinson have seen the world and seen the project of Indian law, is to believe in the power of ideas and that we're playing a long game and we can learn from the past and we can also look forward with a commitment to justice, to protecting sovereignty of American Indian tribes, and into thinking about a whole series of challenges that still remain before us. And we are a partner and will be a partner to NARF and to all of the tribes represented here. And I know you've got some phenomenal leaders on our faculty, and I'm just privileged to work with them. So without further ado, let me turn over to Carla.
Thank you, Phil, and thank you, Chairman Gentry, for those inspired words. A great way to start our morning celebrating NARF today, and a great way to start a 4-day celebration of NARF, which begins right now. I feel very honored to have been asked to participate in this conference with the Native American Rights Fund. I consider myself sort of a child of NARF in many ways, having grown up with a lot of the people in this room. And I kind of can't believe I'm standing here in this capacity with you all. So it's truly an honor, and I'm very humbled by this experience. This conference could not have been possible without Sue Noe and Heather Whiteman runs him at NARF, and I'd like to acknowledge them, as well as Christina Warner, for all of the hard work that went into to making today possible. So without further ado, we'll get started today. We have a lot of wonderful people that have come from near and far to talk about the impact of NARF, past, present, and future plans for further impact. And we're starting today's talk appropriately, I feel, with our distinguished professor, Charles Wilkinson, to give a keynote that will set the tone for the day and allow us to think and feel passionately about this subject matter. So thank you so much.
Well, good morning. I'm sure there's been a time, no, I'm not, where I've looked out on more friends and people I admire and have worked with forever. And it's great of all of you to come, and boy, what a great thing to celebrate. I can't tell you how privileged I feel to be making this talk. There's no doubt about it. The pivotal moment in my life was in October 1971 when I walked through the front door of 1506 Broadway as a new staff attorney at the Native American Rights Fund. I have no words to express the personal satisfaction, the love, the beauty that I have received from Indian people, and all of us lawyers in the field know that's the secret of look who we get to represent. And the joy and beauty, too, from their treasured tribal sovereignty. I'd like to pay tribute as we celebrate these 45 years to David Getchus, Tom Fredericks, and John Echohawk, the only people who have ever served as director for this great firm. And each of them in their own way was a force from the beginning and have throughout their careers carried the high ideals of NARF as they've worked for Indian people. Thanks to each of you. They had nothing. They had nothing. They had nothing. I'm writing a history of the Bolt decision, and last spring had the pleasure of spending some time in Seattle where I could interview some of the people involved in that historic litigation. During those separate interviews, 3 different attorneys, 2 from tribes, 1 from the state of Washington, independently volunteered and emphasized those words I just spoke to you. They had nothing. I asked each of them to explain what they meant by that phrase. They mentioned the grinding poverty. By the way, 60% unemployment would be a conservative figure in Indian country for 1970. They variously mentioned physical factors such as the universal lack of indoor plumbing and electricity, the absence of paved roads, and the housing, so much of which could be classified as shacks. They also emphasized the health problems and the very limited educational opportunities. They pointed out other factors indicating the terrible state that Indian people in Northwest Washington faced. Of course, Indians all across the country were in similar conditions. They had nothing. It was exactly that reason that caused Vine Deloria, Charles Loha, and David Risling, and a few other Indian people to establish a national organization dedicated to vindicating the legal rights of Native American people and tribes. Of course, although Indian people lacked a great many things back then, it was not literally true in the late 60s and early 70s that they had nothing. In fact, they had the most important thing: their vibrant cultures, demeaned and battered, to be sure, but still very much part of their minds and hearts. Nonetheless, the national government, the states, and local citizens had taken away a lot and suppressed a lot of what was left. They took away the indigenous economies. Even today, Indian people, when asked how to describe their well-being before white people came, will say that we were rich. That is an economic fact, not a romantic construct. And because those early economies were much more elaborate and substantial than is commonly realized by non-Indians. In the Pacific Northwest, for example, tribes developed elaborate economic markets reaching south to the Columbia and north well up into Canada, to the crest of the Cascades and beyond. Markets for the trade and sale of deer and elk and cultural objects, and especially salmon and other marine specialties. Then the new people came, and after spending decades benefiting from the vigorous native economies, overran those economies with their technologies and capitalism in ways we can't fully comprehend. The outsiders never could get beyond the ironclad assumption that Indian people were inferior to the God-given mission of the westward expansion that was intended rightly to eliminate all native institutions, regardless of how valuable they in fact were. They took away the land. They didn't get it all because the tribes continued to have enough military capability at treaty time to prevent that. After the treaties, many people, both political leaders and common citizens, stoutly believed, and there is far too much truth in it, that if you took away the land, you could eventually take away the culture. John Wesley Powell, the great explorer, policymaker, and philosopher of the West, was explicit about it. He strongly and cravenly, explicitly supported allotment in the late 1880s because, as he wrote, if you could wrench away the land, especially the sacred places, you could wrench away the culture as well. That would, as he and others believed, hasten the moment when the vanishing Indian would become the vanished Indian, which, after all, was the ultimate objective of national policy. They all outlawed many of the old ceremonies. Is there a darker moment in the story of the First Amendment than the relentless regulatory crackdown on native dances and other customs? Some traditional practitioners carried out their ceremonies in the dark, in basements or other hard-to-find places. But for many, the threat of punishment from the United States of America was too real and too severe. Besides, the crackdown came in other forms, such as in the Pacific Northwest, where BIA employees simply torched traditional dance halls. They suppressed the languages, the ultimate expression of culture and worldview in all societies. BIA and boarding schools prohibited native tongues, washing out the mouths of young people with yellow lye soap when they spoke their own languages. Government officials and people in town scorned native speakers. They directly operated on the families. Parents and children were both pressured hard to send the young people to the boarding schools, meaning that these family members would be taken out of the home for most of the year. In the schools, they would suffer nothing short of indoctrination. The students would be told, don't pay attention to your grandparents. They're just old-fashioned. You can be a real American. Inexcusably, federal officials stood idly by in the post-World War era when states and churches began aggressively removing, sometimes amounting to kidnapping, Indian children from their homes and obtaining state court adoption papers in favor of non-Indians. They took away something else. They took away hopes and dreams and optimism and individuality. They took away, at least they tried, the right to be yourself. And by the late 60s and early 70s, many policymakers and legislators were still defending and pursuing the current and ultimate policy adopted by Congress in 1953, outright termination of treaties, reservations, and federal obligations to tribes. It was in this cauldron of experiences that the Native American Rights Fund was born 45 years ago. Vine Deloria Jr. put it right. We better win this one, because if we don't, there won't be another. Not that NARF was seen as the be-all and end-all. Many organizations would be needed, as well as building capability in the tribes themselves. Still, tribal leaders at that time, as they do today, placed great emphasis on the need for lawyers and law reform. Indian people and tribes are subject to so many laws and regulations, and the field is known for its complexity. The new legal services firms on or near reservations, when NARF was formed, were already making their presence felt, and some capable attorneys practiced Indian law in private firms. The hope, and this hope has more than been borne out, was that NARF could play a particular role in addressing national issues, becoming a substantial firm with excellent lawyers, and representing Indian individuals and tribes who needed attorneys on pressing matters that raised issues of national importance, but could not afford to pay lawyers. From the beginning, one of NARF's strengths has been its vision in prioritizing its work to meet the situation just described, and over time adjust the work to meet changing circumstances as tribes made advances and new kinds of needs and opportunities emerged. This ability to meet the particular circumstances of particular times becomes ever more evident when we look at NARF's accomplishment in the early years up through today. NARF's work has also been marked by what was, it's my sense, an unexpected result. At the time, lawyers in private practice, and back then private practice was mostly what law was, attorneys' work was mostly self-contained. You worked on a single project, like a contract, will, corporate charter, or lawsuit. The results might benefit the client, maybe a lot, but they would be mostly limited to the results of that specific project. It turns out that NARF's work has been much more than that. This was partly because it involves public law rather than private law, partly because of the circumstances in Indian country. One example, though it is somewhat more diffuse than others I'll mention, involves one of NARF's core concerns, tribal sovereignty. We have seen over these 45 years how an advance in one discrete area of tribal sovereignty, be it education, health, water rights, jurisdiction, or other, that one victory will likely increase, even if slightly, the general respect for tribal sovereignty on the part of outsiders, influential people, common citizens. And over time, respect for tribal sovereignty will arc toward the establishment of broader and deeper substantive tribal sovereignty. Now, from the vantage point of 45 years, we can see this dynamic in technicolor. From the time NARF started to the way it has played out today. The extraordinary 1974 ruling by Judge George Boulder in the United States against Washington that mid-19th century treaties guaranteed to tribes in the Northwest the right to harvest 50% of the salmon has turned out to be even more historic than that fundamental decision seemed to be at the time. Judge Bold, for example, also ruled that tribes, as sovereign governments, could regulate fishing. Immediately, the tribes leapt into action and formed natural resource departments, drafted regulations, set up enforcement systems with officers, hired fisheries scientists, and upgraded or created new tribal courts. These were perhaps the first modern regulatory systems in Indian country. Then, seeing how well the fisheries agencies worked among individual tribes, the Northwest tribes began setting up tribal agencies for education, health, land use planning, and other purposes. They joined together to form the Northwest Indian Fisheries Commission with deep expertise in science and policy, one of the first intertribals. So, over time, the original decision in U.S. against Washington spread. And among other things, today led to the comprehensive regime in the Northwest for co-management of all fisheries among the United States, the tribes, and the states. The changes went beyond fisheries. The Northwest tribes now have elaborate and substantial sovereign governments, with most of them having 300 or more governmental employees, not including enterprises. Tribes tribal leaders regularly point to the Bolt decision as the triggering point for their broader modern revival. To be sure, NARF has never gone it alone and virtually always has coordinated with other people and organizations. In the Northwest, Billy Frank Jr. and other tribal leaders and activists, and Judge Bolt himself played major roles in that litigation, in the U.S. against Washington litigation. So did legal services and private practitioners who were willing to bill tribes far below their normal billing rates for work on that case. But David Getchus was lead counsel, and he knocked around many ideas with people back in Boulder. And to this day in the Northwest, people honor NARF's central role in that lawsuit that led to a thoroughgoing reorganization and restoration of tribal organizations reaching far beyond the bounds of the actual issues in that case. Much can be said about NARF's contributions then and today in being significant contributors to, therefore, the tribe's national movement across so many areas. The dynamic was at work in the United States against Michigan, where NARF played a sturdy role in that case and the tribal revival in the Upper Great Lakes area. So too with Menominee Restoration in 1973, which led directly to the restoration of all terminated tribes, the recognition of non-recognized tribes, and the formation by all of those tribes of active and effective sovereign governments today. Menominee Restoration never could have happened without the energy and talent of Ada Deer, Sylvia Wilbur, and other Menominee leaders and activists. But NARF played an effective role there. Many of the revived eastern tribes have built their modern operations upon the eastern land claims cases, where NARF broke new ground. At Pyramid Lake in Nevada, the Pyramid Lake Paiutes and the leaders achieved true, comprehensive watershed restoration in the Truckee and Carson drainages, and then put together expanded tribal governments in the fashion scene in the Northwest and elsewhere. But it never would have happened without the all-out commitment in the litigation, to the litigation that the Native American Rights Fund provided. By the mid-1980s, Walter Echohawk, with help from Steve Moore, was hard at work fulfilling one of Walter's life dreams, combating the scourges of excavation and stealing traditional cultural objects and human remains. Numerous lawsuits and litigations finally funneled into the Native American Graves Protection and Repatriation Act of 1990, one of the most luminous accomplishments by NARF and all of Indian country. Essential to NAGPRA was the effort put in by religious practitioners who patiently explained, often in their own languages, the horror of the problem and how deeply Indian people wanted to make inroads into it. It also was an occasion where the beauty of the law, which we do not often enough witness, can be seen in full flower that is due primarily to the legal genius, traditional roots, and all-out commitment of Walter Echohawk, who, through NAGPRA, changed the world. Over the last 20 years or so, NARF has both solidified its position as a main guardian and coordinator for the whole field of Indian law, and as well has moved into new and exciting areas. From the beginning, NARF was a watchdog for the whole field. For example, doing amicus briefs in for every Supreme Court opinion, and trying to work with other attorneys to have, as best we could, with so many attorneys coming forward, which is a positive thing, but also harder to coordinate. And NARF trying to help that approach. At the same time, NARF has continued its sacred obligation to represent tribes with limited resources and significant legal needs, and as well as maintaining its centrality in the national Indian law community. Eventually, we saw a change from NARF doing those amicus briefs, which many people commented on as being always read by the court. And NARF does still do amicus briefs, and important ones. But since 2001, we have had the Supreme Court project, where NARF has a lead role. No, we haven't got a lot of great results, but that is due to the court, not us. This project, with attorneys across Indian country working together, has built a solid system for putting our cases before the court in the best possible light. Strategies such as whether and how to handle cert are addressed in great depth. When the court once takes the cases, briefs, including amici, are identified and assigned to different people, and they're polished, and the cases are then argued by the best lawyers. It isn't easy. The 90-party conference calls are horrid. I heard 90 people laugh. But the Supreme Court project has become a necessary, effective, and permanent cornerstone of tribal advocacy. The trust relationship has long been under fire, and we must protect that foundational doctrine as best we can. NARF sees itself as the watchdog for the trust, and large results followed from Eloise Cobell's call to John Echohawk to do something. In the end, the individual allottees in the final settlement received less than they deserved, but the payments were reasonably substantial. There are creative provisions built into the settlement. The land buyback provisions have already returned 1.5 million acres to tribes, and there is more to come. Most of the tribal, as opposed to individual cases, and the tribal cases were legally difficult, have settled, and the results have been highly satisfactory to the tribes. NARF has taken a leadership role in yet another foundational and complex area, the settlement of tribal water rights cases. From the beginning, tribes looked to NARF for leadership in the water area. In the 1980s, NARF made contact with the Western Governors Association and the Western States Water Council, and they joined in an effort to set a context for settlements in recognition of the fact that for all water users, including developers, states, and tribes, settlement can often be the preferred alternative over litigation. A major conference organized by NARF has taken place every 2 years, and the doors of water users, state offices, and the tribes remain open. Congress has enacted 29 major water settlements, with NARF attorneys handling 9 of them and others and offering advice in most of the others. There's still more work to be done, and NARF will be right in the middle of it. Native people know their homelands, and far more than most citizens of this country understand the destructive march of climate change. Tribal villages in Alaska, Northwest Washington, and elsewhere have already been affected by rising ocean levels. All across the country, Indian people who know the land are seeing and feeling the impacts on forests, rivers, rangelands, and animals. NARF is working to assure that sustainability will be eventually reached, and that the tribes will be treated as sovereigns in state and federal assessments and planning for public land and water resources. The climate change work dovetails with NARF's involvement in international issues, where since 1999, the organization, often representing NCAI, has been active in the adoption and implementation of the UN Declaration on the Rights of Indigenous Peoples and other matters involving indigenous peoples globally. Among other things, for the past 6 years, NARF, with Kim Gottschalk doing a good part of the work, has steadfastly participated in the elaborate UN Framework Convention on Climate Change process. Progress has been painfully slow, but the stakes are high, and NARF will continue to press for full recognition of the special circumstances and rights under the UN Declaration of American Indians and other indigenous peoples. As you know, there's much more to tell about this extraordinary organization that has changed the world. And obviously I can pretend only to make a beginning on it this morning. But oh, would I ever be remiss if I didn't mention another part of NARF, the Anchorage office NARF North. The specifics vary across Indian country, but every tribe is burdened in some significant way by the weight of history. Alaska is as bad as it gets. ANCSA of 71 was an abject horror, and for nearly half a century, federal officials have used every part of it they can find in order to brutalize native land, sovereignty, economy, and culture in their campaign against native tribes and people. Larry Ashenbrenner and Bob Anderson staved off a lot and made some progress, and they did it with gusto. Now, we have these 4 wonderful lawyers up there, Heather, Natalie, Aaron, and Matthew. They've taken on about every issue you can name in that big state, from voting rights to Indian child welfare to water, fishing and hunting, and land into trust. And somehow, ultimately, after the Supreme Court's Venati decision, about as wrong-headed and devastating as a court decision gets, they have impossibly, piece by painstaking piece, made significant progress in resurrecting the sovereignty that seemed lost forever. So, I'd like to finish off with a toast. It's early in the morning, but in your pockets and purses, you must have stuff. And I'd like to offer a hearty toast. A hearty toast to the attorneys and staff, past and present, of NARF North, and to the attorneys and staff, past and present, of all of NARF, who together have carried so high the banners of Native people, tribal sovereignty, human rights, and the banner of the best law firm ever. A toast. Thank you. Oh, thank you.
I'd like to ask panel 1 to take their seats. Hey, Carla.
I just have to hold it.
Oh, yeah, and I'll meet it.
So who's first? So we'll start with Arlinda. Okay. And then you, Melody, and Tom. Okay. Does that work? Okay. Okay.
So Melody's really the PowerPoint.
Okay.
It's on here. There's this little screen here. When it goes on,
Okay.
press to unmute video in the setting of the screen, and she can run it on this keyboard.
Okay.
Okay?
All right. Okay. Sounds good.
Pretty self-explanatory.
I'll show her that when she comes back in. And then the time cards are over here.
She's got them.
Okay.
Green button, and then you run the PowerPoint on the arrows.
Okay.
Cool. Okay.
And then you just want me to kind of kick it off wherever we're ready to go.
And are you guys doing Q&A or no?
Yeah.
at the end.
Yeah,
Okay, so I'll get a mic.
Okay.
Yeah, that'll help.
Yep. Okay. Sounds good.
All right, we'll open our panel discussions today with the first panel, which is Protecting Tribal Existence and Tribal Sovereignty.
Thanks, Carla. Hi, everybody. My name's Joel West, attorney with the Native American Rights Fund DC office. And it's a real pleasure to be here for everybody today, and especially to moderate this panel on the protection of tribal existence and tribal sovereignty. Of course, that's a very broad, big topic, so we had to find some ways to narrow that down a bit. So we're going to focus in on ways in which the protection of tribal existence and tribal sovereignty has been accomplished through legislation, litigation, regulation, but also, I think importantly, in the ways that tribes have asserted themselves in that governance space, and thereby preserved existence and tribal sovereignty. And we have a really fabulous panel to talk about those things here today. So I'll give you kind of the high points of their very long and impressive bios, all of which are in your conference materials. But they said just give the high points, so that's what I'm going to try to do here. Arlinda Locklear is a citizen of the Lumbee tribe, North Carolina. Her career began as a NARF attorney in 1976, and she was with NARF until 1987. Among her many accomplishments as an attorney, she was the first Native American woman to argue a case before the United States Supreme Court. And she is currently in private practice in Washington, D.C. Ada Deer is a citizen of the Menominee tribe of Wisconsin. She has the unique distinction of being first a NARF client, then an employee, a board member, and then a board chair. So quite unique in that way. She was also Assistant Secretary for Indian Affairs from 1993 until 1997. She's currently a lecturer emerita at the University of Wisconsin. Melody McCoy is a staff attorney with the Native American Rights Fund in the Boulder office. She's a citizen of the Cherokee Nation, and she has been a past chair of the Federal Bar Association Indian Law Conference, past president of the Colorado Indian Bar Association, and a past board member of the Native American Bar Association. And she is currently a member of NARF's Litigation Management Committee. Tom Fredericks is a citizen of the Mandan, Hidatsa, and Arikara Nation. He was executive director of NARF from 1975 until 1977. He was also an assistant secretary for Indian Affairs and is currently a partner at Fredericks, Peebles, and Morgan. So please welcome this panel. And we'll start with Arlinda.
Thank you. Good morning, everybody. I'd like to start by taking a point of personal privilege, if I may. The Native American Rights Fund, as Charles so eloquently explained to us, is a unique and wonderful organization. I was the first Eastern Indian that was hired by NARF. Tom Fredericks took a big chance on me in 1976. Not only was I Eastern Indian, but I was a member of a non-federally recognized tribe, and the most controversial non-federally recognized tribe to boot. Nonetheless, Tom hired me, and then I had the great advantage of being trained by some of the best lawyers in the business, including John Eckelhawk, Bruce Green, Rick Collins, Yvonne Knight, even though I had no academic training in Indian law when I was in law school. So I owe to them my career, the development of the passion for this law, and I'm very grateful for their vision and for their personal contribution to my career. In fact, let me say one additional point in that regard. John may not even remember this, but when the Solem v. Bartlett case was assigned, that was the first case that I did at the Supreme Court. I was a real young lawyer, just barely old enough to practice before the Supreme Court, and all of the wise heads in the business told John that that was not a wise move, that he should assign it to some of the more senior staff or let someone outside NARF do it, and he said, no, I think we've got this. And he insisted that I would do it, and I appreciate that. Thank you, John. That being said, that gets us to the subject today, tribal existence. This is a subject that is near and dear to my heart as a member of a non-federally recognized tribe because it goes to the core of what we all do. It is the fundamental issue. And I think it's important that this be addressed by a non-federally recognized Indian because it does not depend on federal recognition. It does not depend on any act of bestowal by the United States. In fact, it exists as a matter of sheer political will by the Indian communities that exercise it. It exists because Indian people, indigenous communities, decided on their own, through their own political processes, that they would maintain themselves, maintain their independence, and continue to govern themselves through their own traditional means. That's what tribal existence means. It doesn't depend on any act of bestowal from the United States, any state, or otherwise. As a result, it exists whether an indigenous community is federally recognized or not. And it is the fundamental concept of federal Indian law. All other rights flow from this, with one significant exception, and that is the so-called half-blood exemption in the Indian Reorganization Act in 1934, which does bestow individual rights on so-called certified half-blood Indians. But apart from that major exception, all the rights that you'll hear about today and that are discussed, including that fundamental attribute of sovereignty, flow from tribal existence. So it is the basis of all federal Indian law. And it is one of the first priorities of the Native American Rights Fund. In their wisdom, the first board of directors of NARF set a set of priorities to govern the decisions that would be made in terms of cases that would be taken, and self-conscious efforts to develop a favorable body of federal Indian law with regard to those issues. Tribal existence was one of those. As a result of NARF's work and the influence of others as time passed, the tribal existence issue became to the attention of the United States. Oddly enough, for the first 200 years or so of federal Indian policy, notwithstanding the continuous dealings with Indian tribes, there was no federal policy that governed the idea that these indigenous communities existed and that the federal government had a responsibility to recognize them as such. Mind you, as I indicated, they continue to exist whether recognized or not, but the act of recognition, which didn't create them, but simply acknowledged their existence and is therefore sometimes referred to as federal acknowledgement, did give them the shield of federal protection. It gave them the shield that allowed them to stand immune from the application of state law in most respects, and that gave them a sphere within which to exercise more freely their rights of sovereignty. But nonetheless, that policy didn't exist for the first 200 years, roughly, of federal Indian affairs. Mind you, tribes were recognized, but they were recognized as an incident to some other federal activity. If the United States needed to settle peace with a hostile Indian government, they concluded a peace treaty. As a result of that treaty of peace, the tribe became recognized. If the United States desired land that was still occupied by a particular indigenous community, the United States again treated with that community for the purpose of acquiring their land. And again, as an incident of that treaty, that tribe acquired the status of federal recognition. So there were a number of tribes that were recognized in their indigenous capacity by the United States, but never as a self-conscious matter. This began to change in the 1970s, and it began to change as a result of really three different dynamics. One was on the West Coast, the fishing rights case that Charles spoke about, the Judge Bolt decision. Judge Bolt also declared, after his original decision in '74, he decided 2 years later that those rights, those continuous treaty rights, were not only vested in those recognized tribes that held them at the time, but also were maintained by tribes that for one reason or another were no longer federally recognized by the United States. So he established a process where these so-called unrecognized Indian communities could approach his court under a set standard and establish the right to participate in the treaty rights that he declared in 1974. all of a sudden then, for the first time in the West Coast, courts were beginning to consider, what does tribal existence mean? How do we adopt a standard that determines that, and what's the process that's going to be used? At roughly the same time, on the East Coast, the land claim cases had begun to be litigated again by the Native American Rights Fund. Early on in those cases, federal district courts in several determined that the Indian Trade and Intercourse Act, under which Congress purported to regulate the acquisition of land by tribes in a broad sense, was not related to or not tied to directly federally recognized tribes, that it applied instead to protect the lands of all tribes that existed as such. So again, federal courts were faced with the decision, how do we determine who those tribes are? Which tribes fall within the scope of the protection of the Non-Intercourse Act? Third, there was at the same time and shortly thereafter, deliberations by the American Indian Policy Review Commission, chaired by Senator Raberesk. And Senator Raberesk made it his business to ensure that that commission, among other things, examined the historic non-policy of federal recognition of Indian tribes. Through the deliberations of the American Indian Policy Review Commission, the Congress made it clear to the Department of the Interior that if the department did not act itself to adopt a policy regarding federal recognition, that the Congress would do so itself in the form of federal legislation. Senator Raberesk introduced a bill to do just that. So by the time of the mid to late 1970s, you had these three separate forces come together to produce such pressure on the department that finally, in 1978, for the first time, the Department of the Interior adopted a set of regulations governing the extension of federal acknowledgement to Indian tribes. NARF played a key role in the formulation of those regulations. Various attorneys at NARF, including myself, commented on those regulations and encouraged the department to finally take this step of establishing a process by which tribes that were not then federally recognized but had continued to exist as such could achieve the status of federal recognition. These regulations established a mandatory process that defined identified seven criteria that tribes must establish to prove themselves eligible for tribal recognition by the United States. These mandatory processes included criteria that had historically been looked to by federal courts, both by Judge Bolt and in the Eastern land claim cases, to identify an Indian tribe. They focused on the existence of a community that had continuously exercised internal political processes and that were obviously composed of indigenous people. It's that political process and that political classification that is key to understanding both the recognition issue and the tribal existence issue, whether or not recognized. Because it is that distinction, that political classification, that makes tribes unique under the United States Constitution. Because of that political existence, tribes are not racial classifications that may run afoul of the 14th Amendment. Instead, tribes are political entities. And because of that, the Supreme Court has ruled time and again that that exempts tribes from laws that would otherwise apply to review so-called suspect classifications of racial designation. It is not a racial designation, it is a political classification. So that became the focus of the regulatory process. These regulations were amended first in 1994. The one significant thing that revision to the regulations provided for was, for the first time, some acknowledgement of the fact that tribes that had been, quote, previously acknowledged by the United States were entitled to some special status or some diminished showing under the regulatory process. Now, in my mind, that raises a good question as to, if those tribes exist, why do they have to even come into this process at all? If a tribe is federally recognized, the rules under the Supreme Court have told us again and again that that's a unique status, that if granted by either the political branches or Congress, can only be taken away by Congress. Nobody can interfere in that special relationship unless Congress determines that it's going to modify or even abrogate that relationship. If that's the rule, and if a tribe can establish that at some point in its history it enjoyed that relationship with the United States, it raises the question then of by what power and authority was that right and privilege ever taken away from a tribe, such that the tribe was required to then again go through the administrative process to once again reestablish that relationship. That is an intellectual conundrum that no court, nor any administration has faced full on, and it results in some absurd conclusions. I'll just give you one example, which in my mind is particularly appalling. The Indiana Miami tribe, Miamis of Indiana, were in their Aboriginal territory, which became the state of Indiana from first white contact. They had treaty relations with the United States. As late as 1854, the Miami tribe signed a treaty with the United States by which the United States removed a number of the Miami people to Oklahoma, and the United States acknowledged that there would be Miami people remaining in the territory of Indiana who were allowed to stay on treaty-protected allotments for Miami people. For the next nearly 50 years, that relationship continued to exist. The Indiana Miami were deemed a federally recognized tribe. Nonetheless, in 1897, with the stroke of a pen, a lawyer at the Department of Justice said, because you've been allotted, I deem you to be no longer a participant in the process of the federal relationship. You are deemed terminated, and 75 years later, the United States said, now you must go through our administrative process. Those issues remain unaddressed. Let me briefly conclude with the following comments. We now have new regulations were ratified adopted by the department, promulgated in June of this year. We have a number of questions, like the question of previous federal acknowledgement, that remains facing those tribes. In addition, there is yet another issue that has arisen of late, under which tribes that were not previously recognized are treated once again as second-class Indians by the federal system, particularly federal courts. And that is the 2009 decision in the Carcieri case. Since the Carcieri decision, tribes, even though they may spend 30 years going through an administrative process to prove that they have always existed as an Aboriginal community, now have to prove that as of 1934, they were under federal jurisdiction so that the department will have authority to accept land into trust for them. So at the end of the day, the process is not resolved. We still have second-class treatment of tribes who have been even recognized by the United States as a result of a painful process. And we hope for resolution of that issue one day, but that work still remains to be done.
Whoa, that's all right. First of all, let me say, wow! Here we are, NARF's 45th anniversary. And after these dynamic presentations by Charles, Arlinda, the opening comments from Mr. Gentry, and my heart just aches when I think of the Klamath. I hardly know where to start. You know, I started out as a lecturer at the university. That wasn't my idea. I got personally recruited by the chancellor of the university, his wife, Truman Lowe, an artist. Some of you may know his name. And he wanted me to come down. I was still chair of the Menominee Restoration Committee, and he wanted me to come down and join the faculty. That wasn't on my list of things to do, but anyway, the humans keep interrupting me in my plans, and it's been an exciting life. So I started out as a lecturer, then they promoted me to senior lecturer, then a distinguished lecturer, and my late brother says, well, better than extinguished. So I have termination. I have restoration. And following these speakers is a daunting task. And then I look out here and I think about all the connections that I have with you all, past, present, and future. And I could be immobilized, but I'm not. All right. So let me congratulate again NARF on its 45 years fighting for justice for our tribes and our people. Remember that Fighting for Justice t-shirt? Well, it's time to reissue it. I'm always telling them what to do. Sometimes they listen, sometimes they don't. I pick up the paper today, courtesy of my dear friend Lucille Echohawk. And what do we, you know, the press. We have to do something about the press. It says, Native American Rights Fund, group in Boulder, celebrates 45 years. Well, they got it half right. But speaking of priorities, and connecting it then to my further remarks, it says, John Echohawk was working for California Indian Legal Services in 1970 when the Ford Foundation provided a grant to start a pilot program to provide legal services to American Indians on a national level. So one thing that they got right here, the program led to the formation of the Boulder-based Native American Rights Fund to preserve tribal sovereignty and sovereign governments, protect the land, water, hunting and fishing rights, etc. So even though they didn't do the best job they could, they got the first priority right. So good for them. They need to be educated, continuous education involved. All right, drilling down here, preserving tribal sovereignty. And the nominees were terminated. I could spend a lot of time on that. I'm just going to say I was told once that the Menominees were the first tribe terminated, and we were the first tribe restored. And as part of this effort, I just want to say a few things about termination so you can have a context for the restoration. Some of you are VISTA volunteers, and let me say they played an important part in this too. Sometimes they don't get the credit they deserve. Our tribe was a federally recognized tribe from 1854 to 1954. We are still in our Aboriginal land. We have a beautiful forest, beautiful waters, and most real Indians have this deep attachment to the land and the people. Freedom with reservation. The Menominee struggled to save their land and people. Okay? That's always the basis of the struggle, and many other things flow from that, water rights and so on. Let me just highlight a few things. The Menominees did not ask to be terminated. We carried on a suit against the federal government for a number of years, 15 or 16 years, started in 1935, got resolved in early 1950s. We have this beautiful stand of timber. They grossly mismanaged it, and we won the suit, $8.5 million. It was then decided to introduce a per capita payment. We were one of the three tribes that paid for the services. We were basically self-sufficient, and people felt that it was important to have this money. I'm not going into all the details, but I just want to emphasize some of this. So it was agreed, Senator Joseph McCarthy and Congressman Melvin Laird introduced this per capita payment for $1,500 in the House of Representatives, got to the Senate, before the Senate committee, Senator Arthur V. Watkins. He didn't know anything about Indians, and it was his decision that the Menominees, if they wanted their money, they would have to agree to termination. He came out, waved the $1,500 in front of them. 169 people voted for the idea of termination, 5 voted against it, and then he used this as a consent. Later on, the Menominees really started thinking about this, and they sent in a petition opposing it, signed by around 800 people. That was ignored. So from 1954 to 1961, there was all kinds of studies and so on that were done, but the end result was termination became final. And I want to emphasize, in 1961, I want to emphasize the fact that the Menominees were really not informed about this. They didn't understand it. They didn't have focus groups. And they didn't have informed consent, all these things that we kind of take for granted now in Indian work. So at any rate, I remember talking with a man who was in our traditional village. He says, you know, this termination, we don't understand it. You know, one day, you know, he's looking at his hands and he says, I'm an Indian, and the next day I'm not, but I'm still me, right? So, yes. And so he, in that statement, demonstrates the strength and the beauty and the spirit of Indian people in their own, recognizing their own personhood. Long story short, the tribal rolls were closed. 3,270 were on the tribal roll at the time. The land became subject to taxation. They set up a special corporation. It was a private corporation. See, this society always wants us to become capitalists, and I tell people that Indians are not born capitalists. They're born cooperating and sharing and caring. First thing they did was fire 150 men. They had to go because it wasn't profitable. Before that, the tribes could, if you're a member of the tribe, you could go and get a job in the tribal mill because that was the main basis of employment up there. Health, the hospital was closed. People were no longer identified as Indians. It was ghastly. It was ghastly, a political, economic, cultural disaster. And I want to read what the Menominee Termination Act, to provide for a per capita distribution of the Menominee tribal funds and authorize the withdrawal of the Menominee tribe from federal jurisdiction. One sentence. And it created such havoc, not only for our people, the Menominees, but for all the other tribes. And it's a permanent stain on the American governmental system. Pretty soon, they started selling land, and I'm a short distance away working at another university, and I took that job to be close to my tribe. And I'm reading that the Menominees are demonstrating. I said, what? You know, I have to go and find out about this. So I took a 2-hour drive, got up there, and the land sales were going on. I said, why are they selling the land? Well, they have to make money to pay the taxes. Anyway, I'm going to just drill down again. Many people left. People died. They didn't have health care. People couldn't go to school. It was ghastly to go from the so-called wealthy tribe. Actually, most of the people in the tribe were poor. There were certain classes of people that worked for the BIA, or they had a few other jobs like that around. At any rate, my own sister was in college at the time, and she, whoops, there goes the 5 minutes. I'm going to have to speed this up. She was going to quit, and I said, no, you're not quit. On my little social work salary, I paid her last year in college, so that was hard. So the despair of the Menominees was terrible. So they started demonstrating. I went up to find out about it. I found Joe Prelaznik, the OEO Legal Services Wisconsin Judicare lawyer, talked with him, and the people were and they were in Milwaukee, they were in Chicago, they were trying to figure out what to do. And so we formed a group called DRUMS, Menominee Drums. There are many books that have been written about my tribe. And we then, through the help of NARF, I want to emphasize the position and the wonderful assistance we got from NARF. Charles Wilkinson and Yvonne Knight showed up. Joe Prelaznik called them in, so we had excellent legal help on the ground. on a daily basis practically in Wisconsin, and then they flew in, and there were, I think it was approximately 1,800 hours that they spent flying back and forth. And so at this point, I want to thank the wife, Anne, and all the hours and that were taken away from the children, and the children also. The families really suffer from the absence of the NARF people. At any rate, it was decided we would formulate a bill, and we met, and this came from the grassroots of the Menominee. They decided through first these demonstrations, and then through excellent legal help we got from NARF, and I'm a permanent client of Charles, and I haven't seen Yvonne recently, but I'm going to track her down again. The deer gets tracking. Okay, so we formed fast friendships. We got the bill introduced in Congress. They were wonderful working there along with us. Yes, I was the lobbyist, but I want to emphasize the fact that you can't trust other people. You have to do it yourself. Yes, there are many, many lawyers out there and other kinds of people who get high prices. No, I dropped out of law school. I'm a law school dropout, but I succeeded anyway. And here I am talking to a group of lawyers here, and I have a love of the law, and maybe in my next life I'll be a lawyer. At any rate, the lobby, I didn't take any courses in lobbying. I just decided that, this had to be done, and I was willing to exert every ounce of my energy and fiber of my being to get this done. And there's no substitute for that type of feeling and commitment when you're lobbying for your people and for other good causes. I want to emphasize that fact. Our drums people came in for some of the work there. I convinced the people that in Washington, Congressman Meads, that we should have a hearing on our reservation, which had never been done before. And we had a very good people in the Bureau of Indian Affairs at that time. Uncle Louis Bruce was the Commissioner of Indian Affairs. We had Ernest Stevens and Oneida, who was in the structure. And we had our NARF assistants, who, excellent assistance from Charles and Yvonne. I went to sleep at nights, and they were still arguing the fine points through the night. They were so dedicated. And we crafted the Menominee Restoration Act. The Menominees, grassroots, with good legal help, crafted the Menominee Restoration Act. And let me say, being a social worker, I'm not into dictating to people. I'm into empowering people. I didn't want to be. Oh, I got 1 minute left. Well, okay. I paid attention to the Menominee the words, the Menominee Restoration Act. I want to say what it says here. To repeal the act terminating federal supervision over the property and members of the Menominee Indian Tribe of Wisconsin. Now, lots of people in Washington, they like to put their marks on this. And one day I went into the BIA, and the lawyer said, well, I just came back from a meeting, and we were talking about what were you talking about? Amending? No. I said, I have a bachelor's degree from Madison. I have a master's degree from Columbia. English is my first language, and there's a big difference between amend and repeal. Okay, this big tall guy, he said, okay. So you have to pay attention to every word. And that's what Charles and Yvonne Knight did. They paid attention to the Menominees. They paid attention, and we had many arguments and discussions with the congressmen and senators, and I could tell you some. Senator Nelson, Senator Proxmire, Senator Kennedy, Senator Abresk. But we also had a lot of resistance, and that's a long story, but we overcame that. And when we all started this, we started with the care for the land. When the land started getting sold to white people, and I didn't want to have and they didn't want to see history repeating itself, they started. And then we went from these demonstrations to the sophistication of the law. And we had no real idea that this would be such a significant step in the history of Indian affairs. And let me say this. This is in your packet, the announcements. and so I would urge you to read it, but I would call your attention to the last few words here, and I might go over my minute here, but I can do that for, take a prerogative here, speaker's prerogative. Don't worry, I will summarize it after this. Okay, the act was passed in the House October 16th, 1973. Passed the House by an overwhelming vote of 404 to 3, and the 3 that voted against it didn't make it the next election cycle. That wasn't the reason, but that I think it's for a good laugh. Okay. During the entire year, the Menominee plainly made their compelling case in the House of Representatives. We had subcommittee hearings, and I'm going to pay special attention to one of our elders, Ernest Nikanish, who was one of the oldest tribal member who was ambulatory. He spoke Menominee, and he loved wearing his attire, and he had a cane, and he would talk in Menominee to the people, and they didn't, to give them the experience of not knowing what was going on. And he was an avid advocate for us. Okay. Now, it passed the House, but then in the Senate, it kind of got delayed. And here's what it says. Again, the grassroots of the Menominees. We testified. The most comprehensive testimony during the entire legislation process was given by a panel of 7 Menominees, including Sylvia Wilbur, chairperson of MEI, Theodore Boyd, vice president of MEI, Ben Miller, chairman of the Menominee County Board, Ada Deer, chairperson of the Menominee Common Stock and Voting Trust, Robert Deer, vice chairman of MEI, and Carol Dodge, director of Menominee County Education Committee. These persons represented all segments of the community. Capitol Hill veterans said that they had never seen more complete or impressive testimony. And I think that shows, again, the strong spirit of tribal people using the political process to maintain their land and their culture and their people. The Menominees had learned how to make one part of the American political system work for the Indians. It is difficult to overestimate the significance of the Menominee Restoration Act. For the Menominee, it was the only realistic method of preserving their tribal existence, and for this reason, MRA has become a symbol for all Native Americans. Restoration is not the first reversal in U.S. Indian policy, but it is probably the most important one. It provides evidence needed to show that the American political system, imperfect as it has been and will continue to be, can be used as a tool to preserve Indian people and Indian culture. That's what it's about. So, thanks again to NARF.
Where am I? Cool. Thank you, Carla. We have. Bet you're right. I'm going to go ahead and start here because, well, get some technical things so I can do this little PowerPoint gig. But good morning. When I came to the Native American Rights Fund in the middle 1980s, one of the first things that I was assigned to work on was some Indian education work. And I can honestly say that Indian education is one of the areas where tribal sovereignty has been really hit the hardest. In addition to the federal policies, the historic ones that have been touched on today, the result in Indian education has been particularly difficult because, as you know, especially in kindergarten through 12, the elementary and secondary years of education in the United States, over 90% of Native American students attend state public schools, even on or near Indian reservations. That's how tribes have lost any kind of control or governance over Indian education. So part of my job for the past almost 3 decades has been to help tribes regain some sovereignty over, especially K through 12 Indian education. So now that we have, we need here, let me see if I can, So a lot of the work I've done has been to help tribes as sovereigns to regain that sovereignty. They need some kind of tribal education department or tribal education agency. I was fortunate when I came to NARF that there were already existing authorizations in federal legislation for appropriations for tribes as sovereigns in education. In 1984, as part of the Self-Determination Act amendments, there were authorizations to fund tribes for tribal education departments. Another one followed in 1988 through the Department of the Interior, appropriations for tribal ed departments as part of the Elementary and Secondary Education Act amendments. And another one in 1994. But alas, as some of us know, an authorization is just that. It's an authorization. You don't actually get any money. A separate step from Congress is needed called appropriations. Well, I was also fortunate in the couple decades at NARF, the first couple decades, that we had pretty robust funding for NARF to do a lot of the work that needed to be done to help tribes in this area of sovereignty over K through 12 education. We had Administration for Native Americans grants. We had foundation grants, Northwest area, Bush, Carnegie Corporation. Kellogg took a chance on us too. And looking back, I really appreciate all of this because what we were doing was pretty cutting edge and novel, the idea that tribes as sovereigns could have a role in state public school K through 12 education. The last grant we had was from the United States Department of Education. I'm kind of less involved in education, and the other point I want to make is that most of this funding it's been a good 10 years since NARF had any dedicated, significant funding to do the work in Indian education that needs to be done. The other thing that was really challenging was we had to do a lot of work in Indian country in this area because tribe leaders and Indian parents and everybody was used to the states providing the education. And then, oh yeah, there's committees and programs, and oh yeah, there's a few remaining BIE, Bureau of Indian Education schools, you know, why don't you just send the tribal kids there, et cetera, et cetera. We had to do a lot of work with tribe leaders. And so we'd show up at every NCAI annual and mid-year meeting and explain to tribe leaders why they could still be sovereign in education, even though most Indian kids go to public schools, and what that meant. We had to work with the National Indian Education Association, which is a large membership organization, mostly of parents and Indian educators. And like Ada, there's no shortage of good role models in Indian education in terms of Indian educators and all the things they fought for, including the federal programs. How many people here have been participated in a Title VII, Title IV, or Title V program? Anybody here gone to a tribal college? Okay. All those things that Indian educators fought for were very important, but they also had to learn something about tribal sovereignty in education and what it really means for tribal governance. So we had a lot of work to do with NIEA. And one of the last grants we got from the U.S. Department of Education was to help start a tribal education department's national organization, which goes by its acronym TEDNA, Tribal Education Department's National Assembly. That's now, well, gee, I was just in Portland at the NIEA annual meeting, and TEDNA had its meeting before that. And I think TEDNA is now a good 10 years plus, and it's an organization that NARF helped start and has worked with. So I'm happy the last couple years to report that we have made inroads not just in Indian country but in Washington, D.C. There are 2 pilot programs that the Obama administration has started to fund tribal sovereignty in education. The first one became in FY 2012, the State Tribal Education Partnership Program run through the Department of Education. There's the website, which I know everybody's going to click on that right away. But there are four tribes and states that are grantees of this federal appropriations for tribal governance in education. And they are Chickasaw and the state of Oklahoma, Navajo Nation and the state of New Mexico, Nez Perce and the state of Idaho, and Umatilla and the state of Oregon. Okay, so again, we're talking co-governance in K through 12 education between states and tribes. And the BIE, the Department of the Interior, matched this somewhat in FY 2014 very recently with a new pilot program called Sovereignty in Education. There's their website. And the first grantee tribes are Standing Rock Sioux, Tohono O'odham, Gila River, Navajo, Turtle Mountain, and Oglala Lakota. So these tribes are participating in new pilot programs, getting federal dollars to help increase their capacity to govern in education. And then the Interior Department has come through recently with flat-out funding for FY 2015, $2 million. And there are the recipients of this: Hopi, Navajo, Standing Rock Sioux, Acoma Pueblo, Santa Clara Pueblo, Oglala Lakota, and Rosebud Sioux, which I'm proud of because that was one of the tribes that I worked with from the get-go. So all of these tribes are now, finally, we have accomplished getting the federal dollars to them. And that's not so weird. You know, states all have education agencies. And about 40% of the operational budget for state education agencies comes from the federal dollars that they get. So there's nothing strange about this. What is important is that there's, these are some of the pilot tribes. There's 250 tribal education departments, though, around the country. We need more than just 2 million. So NARF will continue to work to help tribes in this area. And I think it's a very exciting time. I'm pleased to be a part of it. And there is a state, anybody here from, there's a new state that in 2013 became the first state by state law to authorize state tribal compacts in education. Anybody? Washington. So I just conclude because I think it's important. This is really historic. State tribal compacts in education. Gee, we got 250 gaming tribal state compacts. You've heard about the water rights compacts. So I always tell tribe leaders, you can do it for your revenues, you can do it for your resources, you better start doing it for your kids. This is what we need, is co-governance, and this is what NARF has put a lot into. The other area that I've been assigned at NARF is these tribal trust cases, some of which Charles alluded to. In 1820, the federal government started holding funds, mostly the money that it was paying to tribes for the land that it was taking by treaty, started holding these in trust, and as of FY14, the federal government says it still holds $3 billion in trust for over 250 tribes. The problem is that no tribe ever has gotten a full and accurate accounting of its trust holdings from the trustee. That is a long time and a lot of money for a trustee to have without providing an accounting. So when I came to NARF in the 1980s and 1990s early on, Congress was trying to address this, agencies were trying to address this, federal agencies, and private contractors like Arthur Andersen and Price Waterhouse were trying to address this. And no one could quite figure out what to do. So we took to the courts, And by 2007, over 100 tribes were suing the United States for breaches of trust, following the Cobell case primarily. And as was mentioned, it's now known that several tribes reached settlement agreements with their cases with the George Bush administration. The Obama administration has settled the cases of well over 80, almost 90 tribes for $2.8 billion or more. And to some extent, that is a reflection that it takes a long time to get these cases to trial, about 10 years if you can get it to trial. So again, each tribe as a sovereign has an option to, if settlements are offered, to negotiate a settlement agreement. The other area at NARF that I worked on from the start was this area of tribal courts and civil jurisdiction over non-members. And actually, even before I worked at NARF, I was in law school, University of Michigan in 1985, when a visiting professor by the name of Charles Wilkinson was teaching Indian law. And this decision came down about tribal courts called National Farmers Union. And the court said that the argument that an Oliphant, U.S. v. Oliphant, which had been decided by the court in 1978, and said that tribes did not have criminal jurisdiction over non-Indians that were on reservations. That was tried to extend in National Farmers Union, and the court very clearly said, although not unanimously, that an Oliphant rule is not automatically extended. Civil jurisdiction is not automatically foreclosed like Oliphant. And of course, we've seen a number of cases, the Strait case in 1997, the Hicks case in 2001, the Plains Commerce Bank case more recently, where the court has kind of left open a lot of issues regarding tribal court civil jurisdiction over non-members. And of course, this term we have the Dollar General case versus Mississippi Band of Choctaw Indians, involving claims by the family of a Choctaw youth minor who was allegedly molested by the manager of the Dollar General store that operates on the Mississippi Choctaw Reservation pursuant to a lease with the tribe, and took on the youth as part of the tribe's youth program where youth get employment opportunities and mentored by businesses on the reservation. So this case will be argued on December 7th at the U.S. Supreme Court, and Dollar General is asking for the Oliphant rule, that tribes have been completely divested of jurisdiction over non-members. In the alternative, Dollar General seeks a rule that tribes do not have civil jurisdiction over civil torts committed by non-members on the reservation, or that if there is any civil jurisdiction in tribal courts over non-members, it is contingent upon an express and unequivocal consent by the non-member. So those are just some quick reflections on what I've been doing for 29 years, and hard to talk about it in just a few minutes, but I really appreciate the opportunity. Thanks.
Well, I guess it's my turn, like Charles, to know that I let all the ladies talk first. You know, this opportunity to speak at this NARF CLE is very important to me, because it's kind of a walk down memory lane to go through all the 45 years of NARF. And I picked the jurisdictional topic, which I think is a very difficult topic, especially for our tribes and our tribal citizens to understand. And I'd just like to say that I have some eye problems, so if I stumble in my reading of my presentation, I ask for your forgiveness. But I feel like all the other people that NARF has been a very rewarding experience for me. It gave me a good start, and it has continued to do so, as I'll go through a kind of a history of Indian law for these last 45 years in the areas of jurisdiction, taxation, and a little bit on the trust responsibility. So I'll start by saying the federal government's abuse of American Indians from the time this country was founded to the 1960s is well known. Broadly speaking, tribes have always believed that tribal self-determination and believed that the federal policy toward tribes should be tribal self-determination. And for the most part of this history, the nation's history, the federal policy has been just the opposite. I joined Indian Affairs in 1965 when the official federal policy towards tribes was still the remnants of termination and transferring jurisdiction over tribal members, tribal citizens, and tribal lands to states under Public Law 280. Due to the federal government's failed policies, tribes had lost a massive amount of land, resources, and community, and American Indians suffered the worst socioeconomic indicators in the country. At this time, tribal governments, Indian activists, and any allies that we had were fighting against the federal government to retain our legal rights to political and cultural autonomy. Presidents Kennedy and Johnson worked on a program that became known as the War on Poverty through the establishment of the Office of Economic Opportunity. Through that program, the federal government created a community action program that awarded grants to various small entities and local governments, including tribal governments. This was an important program because it was the first time that the tribes and not the BIA received grants and could determine how the money should be used and spent. Through this program, many tribal governments had the opportunity to take over programs, account for funding, hire personnel, and publicize that the tribal governments were capable of lifting their people out of poverty and to engage in economic development. This was the first step toward the establishment of the federal Indian policy of self-determination. In March of 1968, President Johnson delivered a special message to Congress addressing the problems of the American Indian. In his speech, President Johnson announced the new policy of self-help, self-development, and self-determination for Indians and the establishment of the now defunct National Council on Indian Opportunity. Just a few months later, President Johnson signed the Indian Civil Rights Act of 1968, just 7 days after Martin Luther King had been assassinated. Then came President Nixon, who began the process of making Indian and tribal self-determination the overarching federal policy. President Nixon's special message to Congress on Indian affairs also declared, or also celebrates its 45th anniversary this year. He announced the new federal policy on July 8, 1970. Nixon's message to Congress led to the enactment of much landmark legislation that tribes still rely on today. The inertia for the self-determination movement consisted in part of a small number of individuals working in the Washington, D.C. and in Indian country. These individuals worked behind the scenes in order to create positive change for Indian tribes through the federal government's elected officials. These individuals were Bobby Green Kilberg, who worked at the White House. Reed Chambers, who was associated with NARF, was the Associate Solicitor for Indian Affairs at the Department of Interior. Brad Patterson worked at the White House. Forrest Gerard who was a staffer on the Senate side and worked for Scoop Jackson, the chairman of the Natural Resources Committee. Frank Duchesneau worked on the House side. He worked for Morris Udall, who was the chairman of the Natural Resource Committee in the House. This small group of people, along with the tribes and tribal attorneys, worked diligently to pass the Public Law 93-638, known as the Indian Self-Determination and Education Assistance Act. This act, as amended, is still utilized today to foster and promote Indian self-determination in Indian country. The energy of tribal self-determination grew enormously throughout the 1970s. With the help of the attorneys, including many at NARF, tribes and tribal citizens began the long overdue process of forcing the United States to comply with long neglected treaty obligations and redress for the federal government's longstanding failure to protect tribal interests and communities. As tribes and tribal citizens gained political and economic power, they often faced opposition, the resolution of which could only be determined in litigation. Most, if not all, of the attorneys that represented tribes and tribal interests during this period have worked at NARF or with NARF at some part in their careers. David Getches and Charles Wilkinson, with Charles' help, litigated the Bolt decision that gave the tribes of the Northwest, under their treaty, half of the commercial catch for fish. Rick Collins, who's sitting here, litigated and won a case on behalf of a tribal member to challenge the state of Arizona's ability to tax tribal members who lived and worked within the Navajo reservation. That case gave us the right to enact our own laws and to be governed by them. Dan Israel, John Echohawk, and Thomas Smithson litigated and won a case on behalf of a tribal member after the state of Minnesota assessed a tax on his on-reservation mobile home. These three cases represent a golden age of the Supreme Court's review of tribal jurisdiction. Through these cases and dozens of others tribal jurisdictional cases heard in that era, the Supreme Court repeatedly blustered and affirmed tribal sovereignty, relying on Indian law canons and the premise of the Marshall Trilogy that the policy of leaving Indians free from state jurisdiction and control is deeply rooted in this nation's history. However, as you all know, since the mid-1980s, the Supreme Court has reversed course. Foregoing the traditional principles of Indian law, the Supreme Court has created a largely incoherent and very fact-specific jurisdictional maze. Three cases stick out in my mind as the cases that at the time seemed like contrary fact-specific exceptions to the long-standing principles of Indian law, but have since been cited repeatedly by states and the Supreme Court as binding precedent to further do away with tribal jurisdiction, totally ignoring the 150 years of precedent favoring tribal jurisdiction. The one case is Oliphant v. the Squamish Indian Tribe of 1978, Washington versus the Confederated Tribes of the Colville Reservation 1980, and of course Montana versus United States in 1981. These cases, along with many others, have eroded tribal sovereignty and limited tribal jurisdiction over the last 30 years or more, and have led Indian tribes and Indian policy people to rethink litigating as a as a viable alternative to operating the sovereign and jurisdictional authority of our tribal nations. We have seen continued growth of internal tribal governmental infrastructure, which further tribal self-determination and relative stability to the tribal policy in the federal political bureaucracies. But in contrast, we see federal courts now only providing lip service to the strengthening of tribal governments while working to defeat tribal self-determination. Tribal jurisdiction as it is today is totally different than what it was in 1965. Further, as tribes continue to generate revenue from new sources, including Indian gaming, hotels, refineries, fisheries, wind farms, and smoke shops, the opposition to tribal jurisdiction and the intrusion into tribal sovereignty will similarly increase. One of the specific areas within the already niche practice of tribal jurisdiction that I believe will receive the most attention over the upcoming years is tribal taxation. Tribal taxation of Indians, Indian tribes, and non-Indians who work with Indian tribes doing business is extremely complicated and rife with pitfalls and untested law for even the most experienced Indian law practitioner. Indian taxation deserves serious consideration by Indian law practitioners, tribes, and perhaps most importantly, the United States government. While the BIA has begun the process of pushback against the legacy of cotton petroleum through the new leasing and right-of-way regulations, we still need a complete overhaul and undo cotton petroleum's dual taxation of Indian resources. In the matter of cotton petroleum, which was litigated by one of our NARF attorneys, but was litigated on behalf of Cotton Petroleum. There was no tribe involved, and our trustee was not involved, and so a lot of the facts that should have been in the record were not there because the tribe wasn't able to put forth the devastating impacts that dual taxation would have on them, nor was the trustee able to weigh in with their position as a trustee. And I think cotton petroleum is a perfect example of what a lot of you hear: bad facts create bad law, and we need to do all we can to reverse the cotton's dual taxation. The existing structure allows states to reap billions of dollars in taxation revenue from resources that squarely belong to tribes. This must be changed. State taxation of tribal resources is an intrusion to tribal sovereignty that harms the ability of tribes to develop their economies, replace their failing infrastructure, and to provide basic government services to their citizens. Another topic that I will address here is the disestablishment and diminishment of Indian reservations through judicial system. A tribe's land is the most important cultural and economic asset for most tribes, yet this is another example of the Supreme Court and Federal Circuit's recent trend to ignore treaties and fundamental Indian law principles to invade tribal sovereignty and tribal jurisdiction. The major decisions on reservation diminishment greatly expand the magic language necessary to find a clear expression of congressional intent, even when the congressional intent is archaic, racist, or obsolete. Litigating this type of case is undoubtedly dangerous with the current judiciary. but in some times it's still necessary. For example, the Ute Indian tribe filed suit to prevent state encroachment on tribal jurisdiction back in 1975, and that case is still going on today. And the core issues in the case are the same as when the tribe filed suit: reservation boundaries and jurisdictional authority to prosecute crimes. Just this past summer, the 10th Circuit Court of Appeals ruled for the tribe in what has become known as Ute 6. Ute 1 through 6 span much of the same period of time that NARF has existed, and encapsulates the history that I have been discussing. The Ute tribe had to fight the court to retain its rights. The prior federal policy seeking to destroy tribes has presented significant hurdles for the tribe. Those seeking to diminish tribal sovereignty have been relentless. The Supreme Court pretends that harm to tribal sovereignty is a thing of the distant past, while it issues decisions which cause wide-ranging harm to those tribal sovereign interests. In 1963, it issued a devastating decision against the Ute tribe. The federal political branches have been unwilling and unable to take on the fight to protect the Ute tribe. Fortunately, because of the tribe's self-determination and the tribe's development of its economic resources, the tribe has been able to take on the fight and prevent further losses. Although the Ute tribe has had to litigate their jurisdictional authority within the boundaries of their reservation alone, they have been able to stave off the counties and the state of Utah, as well as the cities, in their efforts to exercise jurisdictional authority over their tribal citizens, where the crime is committed during the reservation, within the reservation boundaries and within Indian country. I know my time is up, so I'm going to just close by saying I didn't get a chance to talk about the trust responsibility, but I'll just say that, it's been my experience that the trust responsibility under the Obama administration has been gravely changed as a result of the Gobel litigation and as a result of the trust lawsuits. I've seen letters from congressional people telling Secretary Jewell not to do anything that would allow the Indians to have damages. And so the trust responsibility is now defined as don't do anything for Indians that would cause them to have a damage claim against the United States. And so that's a very serious position that we're in, and we need to work hard as Indian law practitioners to reverse that trend. And I thank you for your time. Thank you. Did I go over very long?
We have time for a question or two for the panel. People are starting to trickle out, and we're running a little behind, but we'll get back on track if anyone has anything they'd like to ask. Okay, we'll take a break, and we'll reconvene in a couple of minutes with our next panel. Thank you. Hi, we're going to go ahead and get started with panel 2, which is Protecting the Tribal Relationship to Native Lands and Water, and it's moderated by NARF attorney Matt Campbell.
Good morning. Good morning, everyone. How are you? Thanks, Carla, for getting us started. And thanks to CU for having us. Our panel will, like Carla said, will be discussing protecting the tribal relationship to native lands and waters. We have 5 outstanding panelists that will provide us some unique insight into that topic. Because we have one of the larger panels, we decided we're going to have more of a roundtable discussion and open discussion around our topic. So we don't really have any PowerPoints or any materials to provide up here, but there is materials in the CLE information packet of information. So without further ado, I'll introduce the panelists and we'll get started. So first in the middle we have Chairman Don Gentry, who you all heard speak this morning. Chairman Gentry lives in Chiloquin, Oregon. He was born in April 26, 1955 in Klamath Falls, Oregon. Having been raised by his father as a Klamath tribal hunter and fisherman, he's very knowledgeable of the fish and wildlife resources throughout South Central Oregon, where Klamath tribal members continue to exercise their tribal treaty rights and traditional cultural practices within the former Klamath Indian Reservation. Prior to becoming the chairman in May of 2013, Don worked for the Klamath tribes for 25 years as the Klamath Tribes Natural Resource Specialist and served as the vice chairman from 2010 to 2013. Next, we have Dr. Suzan Harjo. She's Cheyenne and Muskogee, and she is the president of the Morningstar Institute in Washington, D.C. She's also a poet, a writer, curator, lecturer, and policy advocate who has helped Native peoples protect sacred places and recover more than 1 million acres of Native land. She has developed key laws in 5 decades to promote and protect Native nations, sovereignty, children, arts, cultures, land, languages, religious freedom, repatriation, sacred places, and water. She's also a founder of the National Museum of the American Indian. And just last year, President Obama presented her with a 2014 Presidential Medal of Freedom in a White House ceremony honoring only 18 recipients. The medal is the United States' highest civilian honor. She was also the lead plaintiff in Harjo et al. Versus Pro Football, the landmark lawsuit to cancel the trademarks for a disparaging name of the Washington professional football franchise. Next, we have Don Miller, second from the end. Before starting his own firm in 2001, Mr. Miller was an attorney with NARF in Washington, D.C. and Boulder for 27 years. Mr. Miller has represented tribal clients before the Supreme Court, federal appellate and district courts, the Court of Federal Claims, Congress, federal agencies, and state courts and legislatures. His practice has focused on land claims and reserved water rights claims where congressional implementation of consensual settlement agreements was the preferred outcome. He's also served as lead counsel in a variety of matters, including tribal claims to unextinguished Aboriginal and recognized title, federal reserved water rights, treaty hunting and fishing rights, sovereign immunity, congressional restoration of the federal trust relationship with terminated tribes, fee-to-trust acquisitions with carcieri issues, navigable waters, taxation, jurisdiction, voting rights, and FERC relicensing. Next to Suzan, we have Professor Robert Anderson. He is a professor and director of the Native American Law Center at the University of Washington School of Law and is the Oneida Indian Visiting Professor of Law at Harvard Law School, where he teaches annually. He's a co-author and a member of the board of editors of Cohen's Handbook of Federal Indian Law in 2005 and 2012, and he is a co-author of Anderson, Berger, Fricke, and Krakoff, American Indian Law Cases and Commentary. He spent 12 years as a staff attorney with NARF, where he litigated major cases involving sovereignty and natural resources. From 95 until 2001, he served as a political appointee in the Clinton administration under then Secretary of Interior Bruce Babbitt, providing legal and policy advice on a wide variety of Indian law and natural resources issues. And finally, at the end there is Steve Moore. He's an attorney with NARF, and prior to joining NARF, Steve was an attorney representing tribes and individual Indians in northern Idaho, and he also represented the Confederated Salish and Kootenai tribes of Montana. As a NARF staff attorney, Steve has represented tribes on complex litigation involving treaty fishing rights and implied federal Indian Reserve water rights, including the Nez Perce tribe in Idaho, the Agua Caliente Band in California, Tule River tribe in California, and the Kickapoo tribe in Kansas in water litigation and settlement negotiations. He's also worked to protect sacred lands and worked on repatriation of human remains and the protection of unmarked Native graves, the religious use of peyote, and the religious rights of Native prisoners. So that is our distinguished panel. And like I mentioned, we're going to have more of a roundtable type discussion because of our large panel. And so I wanted to start out with Chairman Gentry and Suzan Harjo to kind of set the stage for us to talk about protecting the tribal relationship to native lands and water. And so before we really jump in to talk about protecting that relationship, I think it's important to understand what the relationship is and the importance of the native lands and water to our tribal members. So Chairman Gentry and Suzan, if you could jump in and talk about the importance of land and waters to our people, the meaning of it to our people, and then the spiritual connection that our members have to land and waters.
One time when we were doing resolutions at the National Congress of American Indians in the early 1970s, the room became divided, lawyers here and Indians over here, even though some of the lawyers were Indians. And the word that kept being thrown around was pursuant, pursuant, pursuant. And finally, one of the traditional people from the Northwest Coast said, okay, we start this resolution pursuant only to the Creator. And I thought that was a wonderful blend of what we've really done, I think, in the latter half of the 1900s and in this part of the 2000s. We have blended traditional wisdom and savvy with lawyers, learned traditional wisdom and savvy. And that really is what NARF does. A lot of people who were in the federal Indian bar, who thought they were the federal Indian bar, non-native lawyers working in Washington, D.C. for the most part, did not respect Indian lawyers. And one example of that is when I was at the National Congress of American Indians, not as director, which I was in the 80s, but in the 70s, for a while I was communications director and legislative assistant, and I was in charge of organizing the National Indian Litigation Committee. So we chose, of course, the director of NARF and the director of ALTIP and the director of the American Indian Law Center to be on the group of lawyers. It was a lawyers and tribal leaders committee, and immediately the white guys who represented NCAI said that they would call in the debt that NCAI had to their firm, which was about $30,000, which NCAI did not have, if any of those Indian lawyers were put on the committee. And what he said was that the Indian lawyers simply don't have the seasoning, the experience, the knowledge, the know-how. And Tom Fredericks, as director of NARF, I mean, I told on them, you know, sometimes all you can do is tell on them. So they're holding NCAI hostage, and so Tom got furious and did what he did very well, which was to make his case. And we had a compromise, which was that the organizations, NARF leading them, would be the advisory Indian organizations to the litigation committee, which turned out to be a better construction anyway. And so that's where things were, and as far as respect for Indian lawyers in the mid-1970s, 1975 to be exact. And I have to say that just personally, every place I've worked, every appointment I've had, I've involved NARF or dragged them along, kicking and screaming, please do this, please do that. And we've done pretty magic things and created a revolution in museology, created the National Museum of the American Indian, built some fabulous institutions. And I'm very proud of the 5.5 years I worked with NARF as legislative liaison. And part of that was that inside NARF, there was a core group of people, starting with Tom Fredericks and also with John Eckerhawk, working to respect and recognize the rights of traditional people. We began a coalition in 1967 at Bear Butte that led to repatriation law, that led to the Museum of the American Indian, and lots of changes led to the American Indian Religious Freedom Act. And we really worked in a concerted way and worked our way all around Indian country after that. And a lot of us were outlaws when we practiced our own ceremonies, when we practiced our own, we used to tunnel underneath barbed wire or cut barbed wire in order to get to the Cheyenne part of Bear Butte. And at one point, the farmer came over and said, use the gate. And he ended up being such a friend that he gave, when he wanted to cash out and go to Florida, he gave the Cheyennes the first right of refusal for the 120 acres he had of Bear Butte. And we ended up, the Secretary of Interior ended up buying it for us and taking it into trust for the Cheyenne Arapaho tribes and all others who have traditionally used Bear Butte. But that's the kind of history that we were dealing with individually and being sort of inside, outside the law. So I felt that there were people in NARF that I could really depend on who understood that Native people's attachment to the land is something more than a catchphrase. But a lot of time, people don't unpack that and don't understand it, that our attachment to the land is attachment to our ancestors, attachment to place, attachment to the waterfall where we saw that vision, attachment to a migration history, an attachment to a diaspora, where we have a place where we gather certain kinds of natural products and where we find and develop and make sacred objects. All of these are what's kind of thrown into that attachment to place. And it's a blending of practical, we're the descendants of the people who made these treaties for us, for example, and they were nothing but practical. They were everything but practical, including being practical. And so we are a blend of that practicality and spirituality and magic. My emblem for floating place is the snake doctor. I don't know who first called the dragonfly the snake doctor, but the snake doctor is what a lot of the native nations in Oklahoma commonly know the dragonfly to be. And our Cheyenne people and our Muskogee people really depend on the dragonfly for certain kinds of images of migration, of survival, and of repatriation, because the dragonfly has two sets of wings, one for carrying prayers to the people and all the beings on Mother Earth, and the other to transport people to the next world. And then on the Cheyenne side, our great prophet, Sweet Medicine, when he went to Bear Butte before we moved to the west, he went as many different things as a kit fox and other things, but he went one time as a dragonfly. And lots of other nations' cultures have that kind of imagery of beings that shimmer us into transformative existence, and who remind us of place and how we can change. And even for those of us whose ancestors were wrenched from our homelands and plopped down someplace else without authority, without legal authority for that to be done to us, this snake doctor is one of those images that says you can get along any place. You can do it any place. So those are the thoughts I have right now. And I want to really thank NARF, and especially Tom Fredericks and John Echohawk and Tom Tureen, who should be here, for their guidance and their leadership. When I was, during the Carter-Mondale transition, when I was responsible for doing final selection and vetting of different people in political positions, I had a telephone call with John Echohawk and Tom Fredericks and said, okay, here's the thing. We have a chance to have the very first associate solicitor for Indian Affairs who's native. Which one of you wants to be that person? And there was just silence. And John said, the only thing I've ever wanted to be is the director of NARF. And Tom said, good, because I want to be associate solicitor for Indian Affairs. So it was the greatest deal and the quickest one I've ever been involved in. So I want to publicly thank those two for being partners in sometimes outlaws and partners in law and crime.
Thanks, Suzanne. Chairman Gentry, would you like to weigh in on the importance of land to Klamath tribes?
Sure. I was thinking about how to speak about this. I'm a little bit uncomfortable trying to speak for all indigenous peoples or all tribes. It's a little bit awkward that way, but I think I've made some observations and have some understandings that may be pretty universal amongst natives in terms of their view on land and water and all the resources associated with those. And some of these things we could talk a little bit more when we talk specifically about the Klamath tribes from our perspective, but I think it's pretty commonly understood how deeply tied that we are spiritually, emotionally, physically to the lands, you know, and I think it comes from, you know, our creation stories. You know, a creator placed us there. You know, he had plans and purposes for our peoples. He had plans and purposes for the very things that are in our homelands, you know, and those things have shaped our culture in our views. I've thought about our people. You know, we've been one kind of quasi-ethnographic person characterized us as the people of Tulian stone, because we're so associated with the marshes and the lakes, and a lot of our tools are made out of stone, and we have some unique stone tools that we use for grinding the wokus, which is a seed from a plant that grows in the marsh. It was one of our main staples, and we also use the tule and so forth. So in our case, since we were so tied to that, a lot of our culture, a lot of our stories, a lot of our ceremonies that we observed before we gathered the wokus, before we caught our twam, our kaptu, our fish, you know, we're so tied to those things that Creator placed there for us. And people of the plains, of course, the bison, the buffalo, you know, so much of their culture and the things that they taught their people were centered around that, the ethics, the values around taking what you need and using what you take. And so wherever I go, I see that seems to be pretty universal, that our people are so tied to the land. They believe that they're placed there for a purpose, and there's something spiritual and powerful about that. And folks even believe if we're not honored for those people of that land and respected for the stewards, and we're more than stewards too, I believe, the people that Creator placed us to be, and if we're not honored in the manner that we need to, and the resources there and the homelands aren't honored in the way that they need to, things are broken. And I believe our Native people see that everywhere. We see the social injustice, you know, because we know what's right and what should be right in terms of the land and the water, you know, how that affects our resources. And that's why we feel so strongly as we do about protecting wildlife, protecting the resources, protecting the earth and the water, everything that's there. It's a holistic worldview. I have a friend who calls it a community of creation. You know, we're a part of that as Native people. We're a part of all creation, the trees, the rocks, the water, everything that's in existence. So we're a part of the animals. We fit in. And most often we don't think of ourselves as stewards, maybe in some respects, but we're a part of things. Things take care of themselves sometimes, you know. And I just know some things that I've learned from our people. For example, when we'd collect the eggs on the marsh, the duck eggs or the goose eggs, you know, we'd take a few and leave quite a few in the nest, you know. So that's the way that we live, and that's the way Native people live. So our connection to the land and water is so deep, and I think that we're even suffering sickness and emotional and social issues because of the things that have happened to the land and have happened to our people.
Thanks, Chairman. Do others want to weigh in on that? I think that's a good framework to set us up to talk more about protecting that relationship. And so with that, I want to turn to Don Miller. So much of your work has involved tribal claims to Aboriginal lands and restoring title to those lands. And so I just wanted to ask you, in your experience, how have your clients felt about and described their relationship to their homeland? And then also, if in making those legal Aboriginal title claims, were there any legal or other challenges you came across in making those?
Well, if Chairman Gentry was uncomfortable speaking for all of all indigenous people, I certainly am. Don't feel qualified to talk about how my clients felt about the land and the water. What did they say about it? Well, I can only say they didn't say much. And it was something that a white kid from the city just, you either picked up on it or you didn't. I'm not sure I really picked up on it all that much, but one of the things that you didn't mention, and I don't talk a lot about it, but my legal career started in Klamath Falls with the Klamath Indians. And I had gone to school with law school here with Tom Fredericks, and had gotten to know Dan Israel fairly well. And when I got out of law school, I didn't have a job. I was hanging around in Boulder just taking a job working for Mayflower Trucking Company on the docks when NARF said, hey, there's this tribe out in Oregon that needs a lawyer. There's going to be a big distribution of money. And there have been there's been a lot of abuse of trusteeships and guardianships. They need a lawyer to go out and look at this. And so I went in not having any experience in Indian affairs at all, talked to some people at NARF. They stamped approved on my forehead and sent us off to Oregon. And when Cindy and I got in that Volkswagen to go to Oregon, we didn't know whether Oregon was the one next to Canada or the one next to California. And I still don't know. We went to Wyoming and took a left. And the first Indian people that in an Indian community that I'd ever dealt with at all were the Klamath Indians. And, probably lucky that I was pretty much a blank slate. Didn't have a lot of attitudes one way or the other. And so whatever I picked up on was from the openness and the generosity and the welcoming arms of the Klamath people. There was no Klamath tribe at the time. When I got to Oregon, I found out that I was going to be the first executive director of a small community action agency that some Klamath Indians had organized to fill the void after termination. And our task was to try to get some sort of program going for legal assistance, for Indian education, for alcohol and substance abuse, programs to deal with the tremendous socioeconomic upheaval caused by termination. And in the course of that, I suppose I learned enough to get me by in working in Indian land and water matters. But you know, it's certainly not my place to talk about the you know, the fundamental deep connection that I know exists. But I think I've just been fortunate to play some part in trying to follow in the footsteps of people like David Getches and Charles Wilkinson and learn what they've been teaching and use that to in litigation on behalf of Indian people.
In making claims, Aboriginal title claims, were there certain legal challenges you faced? I mean, a lot of tribes, of course, maintain relationships to their Aboriginal lands, even though they may not technically have title to them. But of course, there's claims to be made, which, you know, part of your work was making claims to Aboriginal lands. And were there any uphill battles you had to overcome in those types of cases?
Well, I think the fact that the major land claim cases that I worked on all took 20 years or more to resolve would suggest that there were there were a few obstacles. Yeah, I don't know. It's hard to represent tribes in water cases, but if you represent tribes in land claim cases, particularly in the 1960s and the 1970s, I mean, you had to go into those communities. You had to wear a red wig and a mustache just to, you know, there were, those were different times. When we went to Klamath Falls, initially, we were being followed by FBI agents. And the same was true when we went to South Carolina to begin working on the Catawba land claim. And the challenges were enormous because the political opposition is so great. And you know, I pretty quickly came to the view that these land claim cases were essentially political cases. They had to have a political resolution. And to just engage the local political forces and even to get them to talk about the preposterous idea to them that the Indians could have any remaining rights whatsoever. Those efforts took 3-4 years just by themselves of just constant talking and meeting with people, and because we didn't go into court and say and just sue the states and the landowners right away. We did the research and we said, well, we think that we've got a good claim here. Let's go talk to the governor. Let's go talk to the county commissioners. Let's see if we can. And we couldn't. No interest whatsoever. Well, okay. Let's see you in court. And it was something that the court battles went well until, as Tom Fredericks said, about the mid-1980s, when things started going south. And then, of course, if the courts aren't going to do their job and interpret the law, and they're going to get into this equitable balancing in the early stages of a case, then that cuts the legs out from under the tribes and reduces their political leverage. And so the challenges that we faced, I mean, we saw it in the Fourth Circuit, where initially with one group of judges we were winning. The Reagan appointees came in, we started losing. And so when you're in a settlement context and your leverage is getting chipped away, then what they go for are the jurisdictional concessions. And so our clients were forced into a number of jurisdictional concessions that were just, well, unfortunate. So.
Thank you. Do others want to comment or weigh in on the land claims issue? I think Suzan, you may have worked with Passamaquoddy and Penobscot in Maine, or if others have any comments on that topic as well.
Well, and I was fortunate enough to work with Don Miller and on the Catawba claim, and his very apparent humility and modesty really helped avert several outright wars. I mean, guns were drawn, and there were lots of weapons, and people were facing off between the people who wanted money and the people who wanted land. And Don represented the people who wanted land, and the others we called the cash-onlys or cash-onlys. And we were, so he averted literally a shootout in one set of meetings, and then the next morning we all went our separate ways, and I was driving from Rock Hill, South Carolina to Chapel Hill, North Carolina, to meet up with my husband and children, and then drive on to Washington, D.C. So I'm driving in a rental car, and there's a highway patrol behind me, and I would speed up, and they would speed up, and I would slow down, and they would slow down. I would turn, and it was clear that they were tailing me. So one thing I had to do before I left was the Catawba people wanted me to go and just take a little bit of clay from the Catawba River, that's where they get the clay, the mud, to make those beautiful Catawba pots. And so I went under the bridge, got my clay, came out, and there were the highway patrolmen waiting for me. And so I was really furious, and so I puffed up as large as I could, make myself, and stomped over to their car and said, "Why are you following me?" The governor's office directed us to escort you safely to the border.
That's funny.
The good congressman who represented apparently had given asked the governor to give us all protection, and Mine was just more apparent, and I took, I thought it was something else. Anyway, they were lovely, and we had a great laugh. And finally, I said, "I'm so sorry," and began to walk off. And they said, "Can we ask you what you were doing under the bridge?" So I just wanted to give you a flavor of the times and how difficult it was for the NARF lawyers to navigate these the difficult settlements, the unfortunate settlements, the fortunate settlements. The Passamaquoddies and Penobscots really wanted to focus in this, money and real estate deal on culture and their respect for Mount Katahdin. Even though they weren't claiming Mount Katahdin, they wanted it noted that Mount Katahdin was a sacred mountain, and so the entire group that was the litigation group was really focused on that and spent a lot of time talking about it, as much time as they had taken in talking about other things that you would think were more should have been more prominent in their minds. But that was a huge thing to them. And when the Justice Department in 1976 announced that the Passamaquoddies and Penobscots had a good and valid claim, and they were filing suit and had done so, U.S. v. Maine. But at the request of the Passamaquoddy and Penobscot peoples, they were holding the action in abeyance pending the outcome of settlement talks. Now, all of this was a ruse because we didn't have any settlement talks, but they were giving us space to have some settlement talks. And Tom Tureen was really, he sprinkled some magic dust and created settlement talks, and we got to engage people who understood how important this was to the people, to the native people. Archibald Cox, we asked if he could help us, if he would lend his name even. And he thought about it for a while and called back and said, "Look, I can't, I'm at Harvard and I'm really busy this semester, so I can only give you half my time, and I'll do it on a pro bono basis." So that's the kind of commitment that was being given because of NARF's character and because of the attachment that the native people had to the lands.
Thanks, Suzanne. Talking a little bit about land, I now want to turn and talk about water as well. And I know Professor Anderson, as a litigator and an academic, a lot of your work has been focused on tribal water rights. And so maybe you could tell us a little bit about the importance of water to our native communities, and then also whether or not you have an impression about whether tribes how they're doing in protecting their water rights, and the quality of their water as well.
All right. Thanks a lot. I'll try to. I'm going to do something I almost never do, which is to talk about my own feelings. My wife sometimes says, "How are you?" And I kind of feel like it's kind of a personal question. We've only known each other for 30 years. So I'm going to step out of my usual character and talk about just my feelings. And, I'm a Boys Fort Ojibwe band member in northern Minnesota, but I moved away from home where I grew up in our Aboriginal territory when I was 17 and went to college and into law school. And Charles Wilkinson told me to come here as a law clerk, and I worked at NARF and moved to Alaska. And this year I've taken time off for the first time, and I've been back in that area living in our cabin where I grew up. And
thinking of, and working on the tribal appellate court a little bit, and thinking about how Anishinaabe people moved down the Great Lakes in the 1600s and settled in northern Minnesota and southern Ontario, where wild rice and fish were abundant, and game. And I've been spending a lot of time in the woods and thinking about, as Suzan mentioned, you know, what happened before, and thinking about if I would have gone there in 1620, what I've seen people out in canoes and villages that are, you see remnants of them all over the place. And in that part of the world, water quantity is not a real issue. It's now becoming a quality issue, and it is everywhere in Indian country. And there are mining companies that were there mining iron ore years ago, and now they're back looking for copper, nickel deposits with sulfide mining that threatens to destroy wild rice beds, invade groundwater aquifers, and you know, has the potential of lasting for thousands and thousands of years, as we see with a lot of the mining in the West. And so, you know, thinking about how to protect water quality is something that, you know, has not received a great deal of attention, except when it's typically when it's too late, when there's a Superfund site because of mining activity on a river system. And tribes have done more and more in recent years with the assistance of the Environmental Protection Agency to become sovereign regulators of waters in their territory. And there's more and more interest in that, I think, as water becomes more scarce. The idea that in the West that dilution can be the solution for pollution is false. And so on the water quality angle, there's a huge amount of work to be done. And I've been doing a little bit academically and with some tribes on that in the West. The question of water quantities is, and how tribes are doing. I want to say, well, there's 29 Indian water settlements that have been enacted in the last 30 years. They probably involve about 50 tribes or so, and they've been, you know, varying degrees of success, but they've, on balance, you know, helped secure steady water supplies and other assets to tribes. But when you think about it in a broader context, you get into these lawsuits that NARF has filed repeatedly, and other lawyers or lawyers that left NARF, and you know, the position that we're in these cases is kind of ridiculous, because from the tribal perspective, it's all right, we have this reservation and these water resources that were basically siphoned off by the United States Bureau of Reclamation in many cases for non-Indian use, miles away from the reservation, out of the watershed. It's Aboriginal tribal property, and now it's been stolen, essentially, and you negotiate about how much you're going to get back. And it's, you know, when I worked for the United States government, I did a lot of water stuff for Secretary Babbitt and with the Justice Department, and sometimes, you know, we'd go to meet with tribes, and the people with me who didn't know much about Indian country would say, why are they're yelling at us? We're here to help. We're on their side. We brought this lawsuit. And, you know, all right. I'm glad you're laughing. I don't have to say any more. You know, so the United States has brought a lot of litigation. NARF has been key in, you know, bringing that litigation. And the importance of the work that NARF has done and continues to do is tremendous, but there's so much to be done in the era of climate change. People are always trying to grab the water back, even when the tribe gets it. And once somebody else starts using it, even if they acknowledge that it's yours, it's hard to get it back. And so, you know, it's a constant battle and one that will never end. And I think that NARF has shown the way in terms of the persistence in maintaining the litigation despite turnover on staff and temporary defeats. You know, the Pyramid Lake litigation is remarkable, and you know, it's just something that's not going to stop, and because water is important for physical, economic sustenance, but for spiritual, and cultural importance as well. I mean, I've just being home for this last few months, I've never felt so peaceful, you know, as to be back there. And but I have to say one little story here about coming to NARF is that when I came here as an attorney, I sat down with John Echohawk my first day, and he said I was going to work on the San Luis Rey case in California, and Jeannie Whiting talked me into cutting off my time after the bar exam because this water case was really moving along fast. And I was naive enough to believe her. It's still going on 32 years later. But I sat in John's office, and, you know, John is, you know, pretty unflappable. And he showed it that day to me. He said, have you taken water law? And I said, no. He said, well, Indian law. I said, no. And he goes, okay, you're going to go. He says, you got your Cohen handbook. And I had worked here the summer before, but then, you know, I started working on these water cases, and then got to Alaska and met Katie John, our first client, and worked for 30 years on that case in various capacities, along with Heather Kendall. We thought we won it in the Supreme Court last year, and when they denied review, and we won this fishing case based on the Federal Reserve water rights doctrine only because we knew about it because we were NARF lawyers, because we had learned about this, and because of NARF's existence. And now it's back in the Supreme Court, and we're struggling to stay with that. And it's, you know, I still consider myself a NARF attorney first and foremost, and it's the thing I'm proudest of, because everything I've ever done, if I've done anything, it's been because of what I learned here at NARF. Really warms my heart to be here.
Thanks, Professor Anderson. And Steve, Professor Anderson mentioned the Federal Reserve water rights doctrine, and historically it's applied to surface water. But maybe you could talk a little bit about your work in Agua and some developments there with the reserve rights doctrine.
Sure, thanks, Matt. And it's great to be here and great to see old friends, new friends, NARF supporters. And I can blame something on Bob Anderson. He's not going to come away unscathed today. I had managed through the first 15 years of my career to avoid being saddled with an Indian water rights case. But in about 1994, when Bob moved to Alaska, to thinking that he would escape his water docket, didn't quite work out. I ended up with Don Miller inheriting his work on the Nez Perce litigation and settlement. And much of my career then in the last 20 years has involved water rights. And yeah, there's a lot that we could say. We could occupy 3 or 4 days just talking about Indian reserved water rights. We are involved in a very important case in the Central District of California. The first phase of it is on interlocutory appeal to the Ninth Circuit Court of Appeals on behalf of the Agua Caliente Band of Cahuilla Indians living essentially in downtown Palm Springs. The case really is about an unremarkable, I would think, proposition, and that is a desert-dwelling tribe would have a right to access all available water sources to fulfill the purposes of the creation of their reservation. Now, the Agua Caliente, like a lot of Indian people, have very deep spiritual connections to water and to the land. And the history of Agua Caliente is really wonderful to have learned about the last 5 years. And they were one of 2 indigenous populations in the desert part of the Western Hemisphere that actually had developed the capability of hand digging their own wells. They had learned over time, watching the animals, that there was water underground. And they would, by hand, dig wells and follow the depth of the water table as it would rise and fall in the Coachella Valley, down by just continuing to dig deeper and deeper wells, and the stairs would go in a circular fashion around the outside of the well. That would enable them to live in parts of the valley that were not close to the mountain. It would enable them to capture and store water for those village sites and for hunting and migration around that part of the world. So there is this centuries-old history of developing groundwater in the valley. The two water districts, of course, defend in part their case on the fact that the tribe they assert has never developed groundwater, and they're very careful about it within the boundaries of the current reservation. Well, most of the current reservation is closer to the mountains, and so we have to play with those kinds of mind games and those kinds of strategies in this kind of litigation. I think that, and we did prevail before the judge that we have in the Central District of California, Judge Bernal. He's born in Mexico, educated at Yale Law School. Sorry, not to offend some people in the room, I hope, but Yale Law School graduate. And at oral argument, and we had the four parties, the U.S. intervened at oral argument after rounds of briefs, 3 rounds of briefs by 4 parties, multiple briefs on these kinds of nuanced issues, walked into the courtroom after weeks of preparation, and we had a 20-minute hearing. The judge, 3 days later, issued his ruling, a 20-page opinion, finding this unremarkable proposition, again, as I said, that a desert-dwelling tribe should have access to groundwater. This is an issue that cuts across all of Indian country. Many tribes, not only in the desert Southwest, but throughout the Midwest, tribes in the Pacific Northwest that are worried about saltwater intrusion into their reservations, reservation aquifers, are concerned about groundwater. And so this is a very important issue that's on appeal to the Ninth Circuit. And if anyone wants to talk to me about participation as amicus, tribal groups, please see me today. At bottom, I think the last thing that I want to say right now, and I know we're trying to hold the audience through the beginning of lunch, ultimately we are talking about land and water here. The stakes are incredibly high. The non-Indian settlers that moved in and through the reclamation laws and the homesteading laws and the work of the federal government, as Bob said, in stealing these resources away from Indian tribes, non-Indians took on this arrogant assumption that these are their resources. Flat out wrong, and a lot of us in this room have spent our careers trying to knock down that proposition and to begin to reassert these important property title questions and issues for Indian tribes. Just a quick personal story. Like Don, a city-dwelling boy, I can't pretend to...
Same city.
Same city, God forbid. I can't pretend to understand the depth of the appreciation and connection of Native peoples to the land and the water. But, and I was a Vista volunteer ADA for the first year out of law school. David Getches got me my first job, and I'll start crying if I start thinking of talking about David much, in northern Idaho. And about a month after I moved up there, I went to a meeting of some Kootenai Indians who were involved in fighting a dam and hydroelectric project in northwest Montana at Kootenai Falls. Long story short, we had a 13-week trial before a FERC administrative law judge. We won that case. I got Walter Echohawk involved, got NARF involved. Doug Anderson, who was a NARF attorney now at Sonosky, was involved. We had a hell of a run, and after 10 years, we prevailed before FERC, and the electric co-ops decided not to take an appeal to the Court of Appeals. We had, and I think you talk about moments in time when cases are won or lost. We had a judge from, an administrative law judge from the East Coast residing in Virginia. We decided to have a site tour at the Kootenai Falls. There's a storage project, Libby Dam, above Kootenai Falls, about 10 miles, and we got the cooperation of the Corps of Engineers to turn the water off in the river and to bring it down to almost a trickle. And I had never been out here, but a dear friend of mine, Patrick Lefthand, who was a NARF board member, he's no longer with us. Patrick Lefthand was a medicine man, a Kootenai medicine man. And we crawled out on the rocks that made up the waterfall, and Pat, we took the judge under the rock ledges that made up the waterfall, and under those rock ledges there were red ochre markings where the Kootenai people had vision quested for centuries. So that gives you, that's just one small story about the depth of connection, the temporal and spiritual depth of connection to a place, a sacred place. So while I don't have that personal, intimate connection, you know, and I know Don would have to admit this, you know, he's absorbed or taken on, assimilated some of those feelings from his years of working with Native peoples. So thanks.
Thanks, Steve. And I know we had a lot of ground we wanted to cover, but I think we've been asked to try and get a little bit back on schedule. So I don't know if we have time to stand for questions or if we want to have concluding remarks. 2 minutes. So if there's questions out there, I think we have time for some. Yes.
Thank you, panel. That was wonderful. I'm Mary Gentry from the Klamath tribes, and I have this question. It has been stated that the courts, the law, is tough for me. Political forces and the public have deeply stated notions that the natives are inferior. They have sovereign, inherent, reserved rights, land, water, economic parity, etc. How can this be changed? I wrote your comment down. We have to reinsert that these are title questions. I have watched NARF battle for the Klamath tribes since its inception. I have seen NARF attorneys age in front of me as I have been. I was a young woman when our water rights cases started. I don't even know if my husband was born then.
Not that much older than me.
I've been known as a cradle robber. But it's good because he will take care of me. But it has been something that Chairman Gentry and I have been working on since actually the 70s, is how to Ada said, educate. My father once said, as a landowner on the former Indian reservation, that every 3 years he has to retrain a Forest Service manager who comes in there, and he has to teach him, take him out on the land and teach him what he knows about the forest, the land, the resources, the water. And every 3 years we have to retrain people to how to help us protect our resources. And NARF has been battling for tribes all of these years, and they are the most well-equipped and the most established to do these battles. I also served on the National Affiliated Tribe of Northwest Indian, and seen their laws, seen the way that they've changed, how they present law cases. And but I have that question because this is something that needs to be changed, and we take our lifetimes trying to change it, but how can we tell young people to go to law school and come back and fight for the rest of your life on one tribal water case?
Well, let me just say, that's the work that has to be done, and I really appreciated Melody McCoy's presentation about the education sovereignty work that's being done, which is critical in the tribal colleges that are out there. And You know, it's really tremendous progress. And just one final word about land and the disaster that we call the Alaska Native Claims Settlement Act, with the separation of land ownership from the tribes and the establishment of the corporations and the taking away of federal protection for hunting and fishing rights as a tribal right is something that's really strikes at the heart of everything that NARF fights for. And I'm so glad that NARF has got that 4-lawyer office up there to work on these issues. And they're going to need more.
I'll just answer real briefly.
Sure.
From my perspective, I think, and we're doing that, and I see tribes across the nation. You know, we're becoming more, actually taking our place in the rightful place in our communities. You know, we're standing up for what's right and what's ours, and should have been recognized and honored. And just establishing relationships with folks in government. You know, it's been many years. It hasn't been safe to. As an Indian, to have an opinion in your own community. We're so marginalized and oppressed in our own community. But as we stand up, and I know through our water rights issues and the settlement actions, which I believe, I thank NARF so much for enabling us to be in the strong position that we are in this time, knowing that we're still in the process of adjudication that could go on for many years without settlement. And we're able to address some of these issues, water quality issues, which you just don't address through a water adjudication. But through the settlement, through relationship, through standing up and protecting what is ours, you know, I think that that's a big part of it. You know, communication. I've actually had people in the community ask me, you know, what is this deal about termination? You know, they think of us as being willing sellouts and so forth. And I'm able to share with those folks, and we're able to do that. And so relationships and realizing that our neighbors are our neighbors. I mean, it was traditional for us to welcome our neighbors. I mean, it might have been to our detriment in a sense, but, you know, I always remember what we were taught, you know, that if the only thing that we had to share with our neighbor when they came to visit with us is a flea, we'd share that flea. That's the heart of our people, I think, Native people. And I think that goes a long way as we stand up for what is right and what is ours and continue to work to protect those things.
All right. Well, thank you, everyone, and thank you to the panelists.
We have lunch upstairs in the cafe on the second floor. You can take the stairs, or there's an elevator down the long hallway here on the first floor.
I don't know that this one worked. I didn't seem like it's not. Oh, yeah, no, I had it on, but I was tapping it.
Yeah.